All right, I guess we can get started. Call the meeting to order. Oh, you're not ready, sorry. All right, let me know when you're ready. Okay, we're going to get started with the Planning Commission meeting Thursday, January 9th. And the first thing on the agenda is to call the order. Call the roll.
Okay, Commissioner Taylor? Present. Commissioner Brock?
Present.
Commissioner Isaiah?
Here.
Commissioner Gonzalez?
Here.
Commissioner Blaney?
Present.
And Chairperson?
Present. Next item is to approve the agenda. The agenda does not have to be in the order of presentation, and anybody can change that if they wish, but seeing nobody interested in doing that, do we need a motion to approve the agenda? Okay, I'll accept a motion to approve the agenda as written. We have a motion. Do we have a second?
I will second.
We have a motion and a second to approve the agenda. All in favor say aye. Aye. All opposed say no. That carries. The agenda is approved as written. Next item is presentations and informational reports, and we have none tonight. Next item is public comment. Provides an opportunity for members of the public to address the commission on items of interest to the public. We only have one member there, and he doesn't seem to be interested in making public comment at this time, so we'll move on to the regular calendar. First item is approval of Planning Commission minutes from 12/12/24, which are in your packet. We have a motion to approve the minutes from 12/12/24. We have a motion. Do we have a second?
I will second.
We have a motion, a second to approve the minutes from 12/12/24. All in favor say aye. Aye. All opposed say no. That motion carries. The minutes are approved.
I have to abstain because I was not present, so therefore I have no opinion.
We have one abstention on Commissioner Blaney. Item 2 on the regular calendar is Brown Act training. We have been waiting for this, so I'll turn it over to our attorney, Mr. Nolan.
Thank you, Mr. Chairman. We will try to make this brief because some of it's just a review to some of you, and others it may be something new. Please, as we go through this, as if questions arise, interrupt me and ask questions while we go through it, and then we'll proceed in that fashion. Just go ahead and go to. Maybe I should do it. Which one do I press? This one. Okay. Okay. The Brown Act. The Brown Act is the legislation that applies to all local agencies with regards to the requirement of having public meetings. The state legislature has really no requirements on their part with regards to how they keep their meetings open or whether or not they involve themselves in closed-door meetings, which they do on an ongoing basis. Also, there is another set of rules for other jurisdictions, such as the county. But the Brown Act applies to all public legislative bodies, which you are one, along with the City Council. And it basically provides that you have to do your business in public, in open meetings, and to all persons shall be permitted to join into those meetings. So you cannot do and take on your business and do the things the Planning Commission does behind closed doors unless it applies and satisfies the requirements of closed sessions. I think over the time that we've been assisting the city, we've had one, maybe two closed sessions with the Planning Commission because that you really do not deal with issues that are involved in closed session. The legislative body is the Planning Commission. It's also the City Council. It's any of the committees that the Planning Commission would establish or that the City Council establishes, a Finance Committee, Community Services Committee, those are all subject to the Brown Act and must be open meetings to the public with the agendas posted as they do with the Planning Commission and with the City Council. The less than a quorum exception is all the meetings that you have to have a quorum that's present. The less than quorum exception is if you are involved in a meeting that does not include a quorum of the Planning Commission. On a certain matter, there's not a quorum there when you're meeting with her, so the Planning Commission, then you have to comply with the open meeting laws under the Brown Act. What is a meeting? A meeting is a, yes, sir.
Is that less than a quorum apply to this as well?
No, I don't think so, because the issue of the serial meetings is that you're dealing with issues that are, that come before the legislative body. And it also, it's, concerted plan to engage in collective deliberations. So, no, if you cannot, less than your, three of you cannot engage in serial meetings and ask each other how you're going to be deciding or what your thoughts are on an item that comes before the Planning Commission. That would constitute a serial meeting, even though we don't have a majority or a quorum of that. My suggestion is that you don't engage in those types of activities because we don't want to be in a situation where there are claims that you were talking with each other and making some decisions outside of the public realm and then coming to the Planning Commission and then forwarding those decisions in the public. What constitutes a series of communications right now with all the different things that we have, as I mentioned, email, texting, blogs, social media, letter, case held by a letter circulating for signature by the planning commissioners. All of those types of communications constitute communications that could involve a serial meeting. So we just need to be careful with how you use social media and your emails and any text messages as it relates to your positions as council, as commissioners. On emails, the first statement is true. We don't like email when, emailing things back and forth, or you having, or some of the council members do have their own website or things of that nature. You have to be just, again, very cautious in utilizing email and other types of social media. As it says, emails never go away, and they can create a virtual serial meeting. So, again, be very cautious. You can text each other, text one another if you want to go have dinner, but you can't text one another and talk about issues that will be coming before the Planning Commission or that even within your jurisdiction as a Planning Commissioner. And this just gives you an example of kind of what some of the issues would be, how it would start out, and good idea, I agree, all that could constitute a serial meeting through the emails. And again, we go into issues of blogging and posting and tweeting. Anything that the serial meeting rules that apply to traditional communications also apply again to all the digital communications and the internet. simply posting general city information without personal opinion or comment is probably okay. When we talk about general city information, again, that probably doesn't apply so much to you, to the Planning Commission, because you're not involved in general city matters. You are the planning agency for the city, and therefore your jurisdiction and what you do is directly related to the planning issues and the tract maps and those types of land use entitlements that come to you. You don't necessarily involve yourselves in other general issues involving the city. But again, we just need to be careful with any social media communications that you involve yourself with. Exceptions to meetings or individual contacts or conversations between a member of a legislative body and another person. Conferences, if there are planning commissioner conferences that you go to, and the majority of you go to that, doesn't constitute a meeting. And community and public meetings to discuss topics of local community concerns organized by someone other than the city. So the League of Women Voters or the Chamber of Commerce, any types of public meetings that are organized by another organization, you can go and participate, again, so long as your participation does not involve an item or an issue that would be coming before the Planning Commission for decision. Exceptions to that are just if you're a member of another legislative body, if you're on a standing committee with the city, and social and ceremonial events, so long as that discussion of business is within the subject matter jurisdiction of the Planning Commission. And you will see on the 2024 Brown Act and Public Hearing update that the Attorney General has issued an opinion that if the mayor did a state of the city speech and everybody came, that would, and the council was there, that could constitute a meeting under the Brown Act. The next item, just for your general information, as you know, regular meetings have to be agendized, as they are, with Carol doing a good job and Holly doing a good job of that. They have to be posted at least 72 hours before the meeting and made available to the public. They're always posted on the city website, and they contain, as they do, a brief description of all the items to be discussed and acted on. You cannot act on any items that are not on the agenda. And then special meetings, again, since we've been assisting the city, we've had just a few special meetings by the Planning Commission, and those have to be posted at least 24 hours before the meeting. And then you can have emergency meetings within 1 hour notice to the media. The non-agendized item exceptions, those apply if the agenda is posted, has been posted, and then an issue comes up that is within the subject matter jurisdiction of the commission, and it's a matter that needs to be decided upon by the commission prior to at the most recent meeting that has been agendized. Then there is a procedure that we go through in order to be able to address non-agendized items. And those are emergency situation, subsequent need item requiring immediate action, so long as there's a 2/3 vote of the Planning Commission, and then holdover items which are posted prior to the meeting, not more than 5 calendar days prior to the action to be taken. But I think that the middle one, the subsequent needed item, would be one that would affect the Planning Commission if there was an item that needed to be addressed by the Planning Commission before the next Planning Commission meeting. The agenda has to set forth the items that are always on your agenda, the statement of date and time, general description of the item, of the nature of the agenda, notation that staff reports and other documentation on file with the clerk, and any questions concerning agenda items may be directed to Carol or to Holly. But really, the main thing with the agenda is that you cannot deal with issues outside of the agenda. The public comment portion, we have to have at least one of those in each meeting to address issues of interest to the public. And we always have our suggestion, as we do with the council, is that you take public comment, but you don't necessarily respond to that public comment so that we don't get into long discussions with the person making the public comment, and we refer the person to the staff member who can best answer their question and address the issues that they have that they've given it during public comment. We don't necessarily require speakers to register to come in or use any type of card that they have to fill out and sign and give to the chairman or to the clerk before they speak. We do have time limits, usually 5 minutes per person, and then if that person is representing more than one person, or if they're non-English speaking and have to have a translator, they're entitled to some additional time.
Question.
Yes, sir.
Clarification. So people do not have to identify themselves
Well,
when they want to come speak?
they can identify themselves by their name and whether or not they live in Kingsburg. We don't require that they give addresses or make some other types of identification. But we want them to identify themselves, their name, so we can get it on the agenda and in the minutes of the meeting, and if they are residents of Kingsburg.
If they don't want to give that information, can we prevent them from speaking?
No, well,
It's not required, so you shouldn't do it.
yeah, my position would be that we would need to have their name in order to make sure that it's on the record. Otherwise, we will not be able to provide them with any of the assistance that they need. If they just want to get up and say something and then leave, I guess they can go ahead and do that without giving their name or whether or not they're a resident of Kingsburg. But if they want a stop sign at the corner, then they're going to have to give their name, because we have to be able to respond to that and have staff contact them. The chairman, Mr. Chairman, you're in charge of maintaining decorum in the chamber, and so we don't allow for just interruptions or yelling. Sometimes we get clapping if it's a controversial issue that the commission is determining at any given meeting, but it's up to this chairman to maintain decorum when both from the standpoint of public comment during comments during public hearings that you hold, and also between commissioners. There's no secret ballots. When you're voting on items, everything has to be open as required by the Act. The records, your agenda packet, which is also available to the public, must be distributed along with the agenda 72 hours before the meeting. Sometimes, like today, we provide you with additional items, but we make those available to the public so that they have access to all the documentation that you have for purposes of making your decisions during the meeting. There is an inadvertent error in how we deal with issues involving the Brown Act or to cure items. We can usually get those addressed appropriately. But we usually try to make sure that there isn't any issues with regards to posting of agendas and the open meeting provisions. The violation of the Brown Act can be subject to legal action by an individual citizen and/or the district attorney for the county. And so if there are issues that deal with us missing a rule or not posting things in time, we will get those cured. But there are enforcement actions that can be taken, both from the standpoint of actions against the city and actions against members of the commission for knowingly attempting to deprive the public of information that is relevant to the jurisdiction of the Planning Commission. Again, I don't see this as being an issue for the Planning Commission, but just to provide you with the understanding that there are various types of wait, where am I now? Here we go. There are various types of enforcement actions, both from the standpoint of civil actions and criminal prosecution. So we try not to get involved with those sorts of things. At the public hearing conducting the public hearings, and this is an important feature because you are basically, for the most part, always involved in public hearings, approvals of track maps. For instance, at the last meeting in December, the West Star applications, you had a recommendation for initiating annexation of the property. You had the approval of the track map for the subdivision. You had the approval of the PUD for the tract. And all of those were take place in public meetings. Those public meetings and public hearings, when you do a public hearing, you're acting in a quasi-judicial fashion because you are making determinations based upon evidence that's submitted by staff and by the applicant and other persons in the audience who speak during the public hearing. And so you act in a quasi-judicial fashion. So when we start the public, when you open the meeting, you open the public hearing, and then if there are any recusals or conflict statements, those have to be given at that point in time. And we'll get into that a little bit. And then staff makes its presentation. All the factual questions are asked of staff. And then you open, and we needed to revise this, but then you open the public comment portion of the public hearing, not the public hearing, and take your public comments and receive testimony, and then you close the public comment portion of the public hearing, and it goes back to the commission for questions to staff. And at that time, then, when all the questions have been answered and the commission is ready to vote, you close the public hearing and make your decisions. And so that's how we conduct the public hearings. Recusals are when you have a conflict of interest with regards to an item that's coming before the Planning Commission. Then you are not allowed to participate in that part of the meeting, and you are to leave the room so that theoretically you cannot sit in the audience and make faces at the commission in order to get them to vote the way that you want them to vote. So you have to identify the conflict on the record and then recuse yourself and leave the commission chambers until the matter is resolved. And a conflict most of all deals with any type of financial interest in the matter. that's before the Planning Commission. And one of the common examples is if you own property within 500 feet of the area that is the subject of the Planning Commission's decision, then you would have to recuse yourself. My position with regards to recusal is that even if there's potentially an appearance of impropriety with regards to your participation in the item, if your cousin is the applicant, but you have no financial interest in the project, my recommendation is that you still recuse yourself. And so if you ever get into a situation where it's that, you have something of that nature, you're always welcome to call me. We can discuss the issues and the facts and then make a determination as to whether or not you should recuse yourself from the item on the agenda before the Planning Commission. Parliamentary procedure, major mistakes made at hearings is, again, commissioners expressing opinion prior to the commencement of the hearings. We don't like to debate with participants from the public. And when we deal with commissioners expressing opinions prior to commencement of the hearings, that not only involves the meeting, but it also involves you in public. We don't want planning commissioners discussing items with people in the public that are coming before the Planning Commission. So if there's a project that's on the agenda, you know that it's going to be on the agenda. It is inappropriate to talk with your neighbor or somebody out to dinner with, or whatever the case may be, on those issues that are coming before the Planning Commission. When you're expressing your thoughts or opinions about the matter before it's been placed before the Planning Commission at a public hearing. Yes, sir.
It happens frequently where you close the public hearing and then suddenly two members of the public want to say something they forgot to say. Can you reopen the public hearing?
You can reopen the public hearing and take that testimony. Yeah. You don't have to, but you can. Issues of due process, this becomes an important issue for you also. There may be developers or citizens who want to talk with you about a matter that's coming before the Planning Commission. Developers or citizens who want to politic you, who want to lobby you with regards to items that are coming before the Commission. They want to come and ask you what your thoughts are about it. What could they do to make it more amenable to you to vote in favor? Our recommendation is that you do not talk to them. And that because anything that you discuss with them as it relates to an item before the Planning Commission, you have an obligation to disclose that conversation at the public hearing so that all of the planning commissioners and the public understand what information you may have received from that individual during the conversations that you've had with them. The exception to that is where there's been several times over the years where we've done site inspections prior to the public hearing, or you have done that, you've driven by the property that's subject to the tract map just to confirm where it is and get an idea of what surrounds it, the housing or whatever the case may be. You have a right to do that. And we've even had the commission go out and take a look at sites together as part of the meeting. But I would caution you in having discussions with third parties about matters that are coming before the commission because it just puts you in a difficult situation to then have to disclose that conversation in public before the commission.
So, Mike, if I had a question about something, I'd want to talk to the commission because that'd be a violation, but is there someone I could go talk to in the city if I had a question about something and get a clarification and maybe in my mind straighten things out of what's going on?
Oh, yeah, you can always talk with staff.
Okay.
You can always go to staff and ask whatever questions you want relative to what the matters that are coming before the commission. If you have questions or trying to get things straight in your mind about the subdivision or the property or whatever the case may be, you're never prohibited from talking to staff, you know. If you have a question about, you know, the sewer service or the water service, you can always get a hold of Daniel Galvez, the Public Works Director, or you can get a hold of Dave Peters, the city engineer, if you had a question about that. So you can always talk with staff. You just can't talk with other third parties that aren't associated with the city.
Okay.
But you have to then be careful about then taking that information and calling Paul and Bruce and saying, hey, what do you think about these things? I found out this information from Daniel, and I don't really think that that's a really good, I don't think that it sounds like there's not enough water and for the project, and what do you guys think? Then we get into the serial meeting issues, you know. So you certainly can talk with staff, but you then can't, in essence, convey your opinions to other members of the commission through through those types of communications.
Okay.
Just briefly, actions by, you take your actions by motions, accepting or approving or denying resolutions that come before the commission on the matters that you're considering. You really don't get, the commission really doesn't get involved in ordinances. Those are basically left up to the city council. With ordinances, though, just for your information, if an ordinance comes before the city council and it's going to be approved, the city council will make a motion to waive the reading of the ordinance and pass it to a second reading. We usually don't read the whole ordinance. And then at the second reading of the ordinance, they will waive the second reading and adopt the ordinance. And then the ordinance becomes effective 30 days after the adoption by the city council. Ordinances have to be published in the newspaper for that as part of that 30-day period. And sometimes, if we have really long ordinances, the government code provides us with the opportunity to do summaries of those ordinances for publication in the newspaper. But most of what you'll do would just be on motions, a motion and a second. The chair of the Planning Commission, the chairman, can make a motion only after all other members have had the opportunity to make a motion and have not made a motion. Then the chair can make a motion. Just for information purposes also, if the commission, if there's not a quorum or the commission ties on a matter, 3 in favor, 3 against, that constitutes no action on that item. And so then it fails for purposes of no action by the commission. You can amend motions, as we have done sometimes, but that amendment has to be with the approval of the party the commissioner who's made the motion, and then there could also be substitute motions. But a motion to amend seeks to retain the basic motion on the floor but modify it. A substitute motion seeks to throw out the basic motion on the floor and substitute it for a new or different motion. Many times that will happen most likely when there's no second to the motion, so the motion dies. With some of your decisions, there will be findings that will be necessary. The municipal code, for instance, on a conditional use permit or on the PUD, the municipal code identifies findings that you have to make in order to approve the PUD or the conditional use permit. Many times, the staff reports will identify the findings that you need to make. The importance of the findings is that they are looked at should legal action be brought against the city as a result of a decision by the Planning Commission or by the City Council. The courts will be looking at the findings made to determine whether or not those findings are supported by the evidence which is submitted before the Planning Commission in order to make its decision. Because with the public hearings and the public comment portions of the public hearings and the staff report, those are all items of evidence, oral and written evidence, which you receive in order to base your findings and decisions on at the time of the motion to approve or deny the action to be taken. Yes, sir.
Does the motion have to have a second before it can be amended? In other words, you make the motion, can somebody make an amendment without a second, or does it have to be seconded and then the amendment can be made?
It should be seconded because the motion doesn't become, the motion is not become one that can be considered by the commission until it's seconded. And then you can seek to amend. And then the commission can always continue items on the agenda. You can continue a public hearing. Those can all be done, but it must be done by motion by the Planning Commission. Your voting is always a majority of the commission. Simple. Most of the time we do a roll call vote. Sometimes we don't. If it looks like the vote is going to be close, we normally will do a roll call vote. A tie vote. Best practices, think fairness, merit-based decision, making your own decisions. So, this Planning Commission does a good job of discussing issues. You do a good job of finding consensus. And if you don't find consensus, you do a good job of just working together to get the matters on the agenda taken care of. So these are older updates. I'd like to go, so are there any questions on what we've gone over so far? The main issues with regards to the commission are your activities outside of the commission, as we've discussed, and then handling the public hearings that you engage in making and issuing the land use entitlements that come before you. We had provided you today with some updates on the Brown Act and the public hearing updates. On the Brown Act, there's two bills that affected the Brown Act this year. One dealt with the remote participation in meetings and basically set forth more clearly when you can participate in remote meetings, a commissioner alone. The time limitations based upon just cause or emergency circumstances are 2 times per year if the body meets once per month or less, 5 times a year if the body regularly meets twice a month, and 7 times a year if the body regularly meets 3 or 4 times a month. So there is an opportunity for you to participate in remotely for just cause or for emergency situations. The other thing that goes along with that is that you have to be able to identify if there's any other people in the room with you other than yourself. So that is put on the record. And then the second Brown Act new legislation is that it applies only to closed sessions, and it allows for closed sessions for cybersecurity issues. The Brown Act currently provides closed session for emergency issues dealing with threats to physical parts of the city, such as the buildings and things of that nature. But now with the ransomware issues that jurisdictions get involved with, and the hacking that gets involved with, we are now able to go into closed session to talk about critical infrastructure controls and critical infrastructure information relating to cybersecurity. Yes.
Senate bill, removal of disruptive individuals. What's a definition of a disruptive individual?
Well, for instance, if you're conducting public hearing and we set it at a 5-minute limit on the public comment, and the person continues to speak, and when you ask them to wrap it up and stop, they continue to speak and they are belligerent to the chair, that's disruptive behavior. Or if they get up in the middle of the audience and start yelling their position instead of coming up to the stand and giving their position when you allow them to do that, that is disruptive behavior.
Because I've heard about boards removing people because they didn't like being criticized. Not really the definition.
No. If somebody comes up and criticizes, but they do it in a respectful way, that's not disruptive behavior. You may not like it, but it's not disruptive behavior. And then there are 2 Attorney General opinions that were issued this year. The Attorney General opinions are not legislative in nature, so they're not laws, but they are considered authoritative for purposes of determining what they address. We use them sometimes from a legal standpoint in briefs or other filings that we do with court. The courts will recognize Attorney General's opinions. The first one deals with interplay between the Brown Act and an ADA. The new opinion provided that disabled persons to accommodated through remote participation are required to comply with the conditions the legislature have put on remote participation. And then they issued an Attorney General's opinion, as I mentioned before, that a State of the City address constitutes a meeting under the Brown Act. So again, it's not going to affect the Planning Commission. It's not going to affect the city. I don't think, we haven't had a mayor who's done a State of a City address yet. But if they do, then we'll have to agendize it. And then one thing, a new requirement under the public hearing process is that if you are considering a amendment to the zoning ordinance that affects permitted uses of real property, we will now have to provide 20 days notice to the public instead of the standard 10-day notice. And it only applies to changes to the zoning ordinance that affects permitted uses. So if you're dealing with hearing a conditional use permit or a PUD or something, or a tract map, something other than a change to the zoning ordinance that affects only permitted uses, then you still give the 10 days notice. So we're not quite sure why this was limited to permitted uses, but I would assume that they were concerned that there would be a change so that a use that was permitted would be no longer permitted and would give the people 20 days notice, the public. So you may see that. And that's something that staff will have to deal with in the future. So that concludes our presentation. I'm happy to answer any questions that you may have with regards to the Brown Act or the public hearing procedures. And I thank you for your attention to this very exciting process.